Education Association. Today's first session focuses on curriculum globalization and transnational law. I would like to inform the August gathering that we are profoundly honored by the gracious presence of our distinguished international dignitaries who have traveled across borders to enrich this session with a global perspective. I'm also pleased to share that some of our panelists will be joining us virtually. Before we proceed with session one, I would like to inform the August gathering that the valedictory ceremony will be held at Chintan Bhawan at 1 p.m. and will be graced by His Excellency, the Governor of Sikkim. With the kind permission of the Chair, I shall now take a moment to introduce the distinct dignitaries presiding over and participating in this session. May I humbly request Learned Director, Madam of Sikkim Judicial Academy, to kindly offer khada as a mark of our respect and appreciation. We are deeply honored to have as the chair of this session, Honorable Mr. Justice Ronnie James Govindan, Chief Justice, Supreme Court of Seychelles. We are privileged to have as the co-chair, Honorable Mr. Justice A.H.M.D. Nawaz, Judge, Supreme Court of Sri Lanka. Our esteemed panelist comprises of Honorable Mrs. Justice Pratibha M. Singh, Judge, High Court of Delhi. Honorable Mrs. Justice Mosami Bhattacharya, Judge, High Court for the State of Telangana. We are also privileged to have the presence of Professor E. Kofi Abotsi, Dean, UPSA Law School and Executive Member of the Commonwealth Legal Education Association, who is joining us virtually for this session. We are also honored to have our moderators for this session, Honorable Mr. Justice Somasekar Sundarasan, Judge, High Court, Bombay High Court. Professor Meera Furtado, General Secretary, Commonwealth Legal Education Association, and Head of Business and Humanities at the International Studies Center, University of Sussex. The discussion for this session is Dr. Sumit Bhattacharya, Research Fellow, National Judicial Academy, Bhopal. Thank you, Madam. I now humbly request our learned moderators to kindly begin with the session.
Good morning, everyone. Bonjour to Justice Govindan. Vanakkam, Bhawan, Justice Nawaz. Kuzuz Ampula, all my friends from Sikkim. Good morning, namaste. We'll try and make good with the time we have. We'll perhaps eat a little into the tea time in the break, but we'll try and keep a tight timeline while running this session. We'll have the chair and the co-chair speak with their opening remarks, and then each of the panelists will take just about 5 to 7 minutes. And then Ms. Furtado and I would go around the panel and ask questions. While we may point it to one panelist at a time, the others may feel free to chime in. We want to leave some time for the audience questions as well. May I call upon Justice Ronnie James Govindan to address us?
Good morning, distinguished colleagues, honored guests, ladies and gentlemen. It is my privilege as chair to welcome you to this morning session, where we will look at the theme of profound importance to the evolution of judicial education and the administration of justice across our respective jurisdictions. This session, entitled Curriculum Globalization and Transnational Law, invites us to reflect on a legal landscape that is no longer confined by national borders. Today's court increasingly engage with legal questions shaped by international conventions, comparative jurisprudence, and cross-border interaction and practices. Whether in commerce, human rights, environmental law, or digital regulations. Judicial education must therefore evolve in steps with this reality. It must equip judges not only with a firm grounding on domestic law, but also with the ability to engage confidently with transnational legal principles and global legal developments. The challenges before us is to ensure that our curricula remains relevant, forward-looking, and responsive to the demands of an interconnected legal order. We are privileged to have with us here, as it has been said before, an eminent panel, and it is my pleasure to be chairing this panel together with them. I will not go into the eminent particulars which have been amply recited. Our discussion will be guided by myself, and it is my wish that we keep to the time management so that the progress of our today's different sessions goes well. With these opening remarks, it is my pleasure to invite the moderator to lead us into the discussions. Please proceed.
May I call upon
The
Justice Bhawan
co-chairperson also, please.
in opening remarks?
Good evening, good morning, my dear friends, delegates, and judicial friends, of course, the members of the distinguished panel that we have today. Some of them I know them. I have associated with them on various panels, and of course I met my friend only last night. The theme is quite relevant, as the Supreme Court of Sri Lanka recently delivered a mammoth judgment on environmental law. I was not part of that court, but I would tell you as to how today a judge, an appellate judge, has become a global citizen in adjudication of disputes. When you sit in your court, you are not hermetically sealed. Borderless jurisdictions engulf us, and it is one such case. You may have read this story. There was this ship, a Singaporean flag ship, came to the territorial waters of Sri Lanka. It had some leakage of nitric acid when it was docked in Jordan, and then on its way, it came to Sri Lanka. And then all hell was let loose. The ship caught fire, and the marine life was affected. The ships went on fire for about 1 week. The executive at that time didn't know what to do. Marine biologists were called in. India, of course, also came to the rescue of Sri Lanka, as it always does. Finally, the fishermen and all those public interest personalities mounted this FR, Fundamental Rights petition, in the Supreme Court of Sri Lanka. The case went on for about 3-4 months, and today we have delivered that judgment. If we look at that judgment, we will see how environmental law was discussed, how we borrowed principles from the Oleum case, M.C. Mehta's battles in India, how the treaties, international treaties have come into it, and the final outcome is something worth bringing to attention, this August audit from the audience. The private actor, the Singaporean private actor, was imposed $1 billion on the principle of polluter pays and the precautionary principles. So you could now see the emergence of this global order, that a judge has to be acquainted with international law. And it was one such area. We knew how impactful international law is all about, and the judicial curriculum has to be developed to suit these moving conditions. And then there are MC Mehta's battles in the Indian courts we took note of. That shows how a judge cannot be sitting in his courtroom in an ivory tower. He can't be just hermetically, he can't just seal himself from the influence, and across the Pork Strait, not only across the Pork Strait, across all the straits we have today, we become global judges. As we traveled, as I traveled with a couple of Supreme Court justices recently to the National Academy in Bhopal, we met with the retired Supreme Court justices of India, some of those brilliant minds, and then as we sat down, it was called the Judicial Dialogue. It was not called judicial education, but the dialogue provoked a lot of thoughts, insights, how the two countries, India and Sri Lanka, have benefited from each other, and the jurisprudence is growing. And now the Indian judges were posing questions as to how the basic structure doctrine articulated in that famous case of Nanda Bharati, has it crept into Sri Lanka? These are issues that we discussed. So when I look at constitutional adjudication, comparative constitutionalism, that is one of the themes. These are areas that are engaging our attention today. Therefore, this conference is quite timely, and I have a lot to speak. But then there are others. There's an IP expert whose expertise has gone beyond borders, and of course there are others. And so whose knowledge and themes would be very much useful. And another area that I would like to share is how international commercial arbitration is impacting us. How the international conventions, such as the UNCITRAL model laws, the newer convention, how arbitral awards have become portable, but the lawyers are fashioning arguments in courts to argue the public policy it can be an unruly horse, but with the right man in the saddle, we can reach the destination. There are attempts that are being made in our courts as to how you can expand the grounds of attack of an arbitral award, citing Indian judgments. Right? So now you can't, I myself feel that I cannot be a loner. I cannot be a loner. So this is an inspirational theme that will promote us, that will provoke our thoughts and then guide us towards that ultimate goal of achieving uniformity, certainty, when we globalize transnational law and we reach harmonization. Those are some of the thoughts that I would share with my friend Somasekharan.
Thank you so much.
Justice.
Thank you so much, Justice Nawaz. We are going to, these are some of the abiding themes that the two co-chairs have placed before us. Human behavior is universal. The two drivers of human actions, greed and fear, drive lawmaking anywhere in the world. So what lessons can we learn across jurisdictions on dealing with it? Of course, how a society formulates its laws is a legislative policy choice that society makes. But in the course of enforcement, there will always be gaps and interstices which will need to be filled. In filling those, doctrines are evolved, like the public policy doctrine that was spoken about, or doctrines of conceptual clarity, say in shipping law or securities market trading, insider trading, for example, why a person would do an accounting fraud, for example. The drivers of these would be universal because it's human. So how do we learn from one another something that we're going to have a lot of questions about. I bring in my fellow moderator, Ms. Meera Furtado at this juncture to start off with the questions to the panel. I would request the co-chairs also to chime in if you feel there's anything to be supplemented or elaborated upon in the course of the conversation. Over to you, Ms. Furtado.
Thank you. As my co-moderator said, there are a number of themes. So the first theme...
Sorry.
You can't hear me?
Should we call upon the panelists to make opening remarks very quickly for 5 minutes?
Yes.
Yes. Yes. So, Justice Singh, would you make your presentation? I'd request each of you to use about 5 to 7 minutes, and then we go into the panel discussion. Sorry. Yes.
Please stop us.
Yes.
A very good morning to all of you. Chief Justice Govindan, Justice Nawaz, colleagues Maushmi and Somashekar, dignitaries on and off the dais, colleague judges from across the country, including my own Chief Justice, Justice Upadhyay. We were given a very interesting and a challenging topic for today, and that is curriculum globalization and transnational law, and how we see how cross-border legal issues are going to impact justice dispensation in India. And in my own view, globalization is not an optional thing anymore. It is the operating environment of modern judiciaries. And this we come across on a daily basis when we deal with issues such as whether it is criminal law, whether it's human rights, whether it's commercial law, or an arbitral award, or an intellectual property law. We find this on a daily basis as to how justice cannot be fully dispensed today without being on the online world, without being able to enforce orders across jurisdictions. And every day as judges, whether it's the magistrate who is dealing with a small cybercrime issue in the criminal courts, or whether it's the Supreme Court which is dealing with transnational issues, we do find a lot of challenges today. And the reason for this is obviously, we all know the reasons, and that is the complete permeation of the internet in our world today. And secondly, the entire web which is creating challenges about artificial intelligence, data flows, data servers which are located in different countries. Suppose there's an order passed in India today, how do you give effect to this internationally? Are the companies who are operating this entire internet willing to even abide by any competent court's order? And these are no longer theoretical issues. My intention today would be to show you a few cases to show how these challenges are very much being faced by us in courts while we are dealing with matters. I would like to start by saying, with the Commonwealth, world, we've had a recent engagement under the leadership of our Chief Justice who's here, Justice Upadhyay. The Delhi High Court had the privilege of hosting the Standing Forum on Commercial Courts, CFOC, last year. We had about 60 Commonwealth countries who were attending, and about more than 120 judges who came. Some of the judges who were here yesterday, had participated in that conference. And there was a huge exchange of ideas. It took place at Bharat Mandapam, and it was a confluence of ideas and views and different aspects and dimensions of commercial courts which were looked at. Let me give you a few examples of a couple of cases. This first case was a case of Swami Ramdev, who had alleged that there was a defamatory post on the internet. So Facebook said, we will not take it down at all. Now the question was, can an Indian court direct Facebook to take it down internationally? They said no. It was a big challenge to deal with this case. And ultimately, the only conclusion that could come about is, if the offending post is uploaded from India, they would be willing to block it globally. However, if it has been uploaded from foreign countries, there will only be called what is called as geo-blocking. It will only be blocked for India, but not internationally. So through VPN networks, it could be accessed easily. The same offending post. Now, we are at a loss. There is no other way of doing it. And nothing more could be done as of now. Next case, it's a Neetu Singh versus Telegram. This was a teacher whose copyrighted course material, she used to teach, and her course material was being distributed through Telegram business channels. So Telegram is a platform, we all know about it. It's like WhatsApp. You can, like, instead of WhatsApp business, you can have Telegram business. 500, 600 people on one business channel. Her course material was being transmitted. It was a small case of a copyright case by a teacher. She wanted Telegram to disclose to her who were the people who were running these channels. But Telegram said, no, we are located in Singapore. We would not be able to disclose it. So then they challenged the jurisdiction of the Delhi High Court. We had to then pass a judgment saying the Singapore laws are similar. The infringement is happening in India. The plaintiff is located in India. So therefore, Telegram has to disclose. Then they took a policy decision that in India, whenever there are orders passed by competent courts, we will give effect to that. So these are challenges which we faced. This is another case, third case, SpiceJet, judgment from a reciprocating territory, whether it is to be given effect to under Section 44A of the CPC, and principles of comity were kind of considered in that matter. Another case of Make My Trip and Booking.com. In this, Booking.com was using Make My Trip as a Google AdWord. So whenever you searched for Make My Trip, Booking.com's advertisement would come first. So they said that we cannot remove it, it's our right, we can use it. Google says no. So the question is, this issue is still to be decided by the Supreme Court. There are judgments from different jurisdictions, France, America, England, who've taken different views. India is taking a different view, so it still needs to be reconciled. Now, this is a fourth case on intermediaries. A very luxury shoe called Christian Louboutin, where they were trying to protect the red sole, and they were counterfeits on online platforms. Now, we could, how do you bring them out from the entire world, from the website called Darvies? The question was whether the Darvies is an active or a passive intermediary, and if it is an active intermediary, it could be told to take down the counterfeited listing. Recently, we faced a very big problem in a criminal case. This was a case where there was a missing child, and it was a habeas corpus petition. The missing child was, after 15 days when he left the home, he had put up an Instagram post. So the court asked Instagram, please tell us the IP address from where this child had put up the post. They said, no, sorry, we can't. So at that time, the Ministry of Home Affairs, MeitY, Indian Cybercrime Portal, etc. had to be called. The Ministry of Home Affairs has started something called the Sahyog portal. So all companies have been asked to come on board, but some companies are still resisting, like Meta, etc. So even for crimes, we are not able to get the data that we need from the companies in order to trace children, missing minors, missing boys and girls. Now, another recent initiative by WHO is the setting up of this steering committee for drafting the AI and health document, which just shows how they want to make a model law for the whole world on AI and health. And this was presented in the AI summit by me, and this document is ready. It is ready for publication now. One of the biggest achievements which Indian judiciary has had recently is on the WIPO Lex database, where there are collections of laws and regulations, treaties, IP judgments on various aspects, including standard essential patents. And India is only out of one of the 12 countries whose judgments from across the country, in fact, Bombay High Court, Calcutta High Court, Delhi High Court, and Madras High Court, judgments are uploaded on the database of WIPO-Lex. Anyone who wants to see the leading cases on trade secrets in the world can access this database, and you'll see that almost all these countries are having exchanges, common databases, and improved coordination and collaboration to be able to bring some kind of consistency and uniformity. Now, coming to AI as a tool, I think we've heard a lot about it yesterday. I had a small video, okay, with video of 1 minute, which I wanted to show to all of you. I'll take 1 minute and then I'm done. On how judges can use AI and whether we should use it at all. Is the volume playable? Okay, the volume is not playing in this. So I've shown you a video as to how you can ask an AI platform to actually summarize judgments, to make, we all use law researchers to make summaries of impugned orders when appeals come to us. You can actually ask an AI platform to do that. And it's easily doable because the minute you say, please provide the following factual background, it generates a proper summary for you. And another thing that we could do is our own judgments, we could put it in a particular database and it is very easy to access the same. You'll just see that in the next slide, which is coming up. So an AI can make a full summary for you of a judgment, of an impugned order, and it can also make summaries of judgments which you wish to cite. So now our own judgments, can we use it for making search? Suppose you say, okay, show me the judgment which I've myself given on this particular aspect, GST, for example. So it can pull out all the judgments that you've done on that by creating your own database. Now, case law research is there where there is a problem, because if you ask, for example, give me the cases on POXO, it could give some hallucinated case law. So research, you should not use it. Summarization, you can easily use AI. It will make our life quite easy, but what we cannot do is write judgments with AI. That will be very, very dangerous. 2 days ago, there was an impugned order before me of a trial court in Delhi where the lawyer was arguing that this judgment has been written through AI, just on Thursday. And it has to be now analyzed and seen if the judge actually wrote it on AI. And so the issue is, when we use digital technologies, we should be willing to use them for the good of the litigants. But what we cannot do is, we cannot use AI hallucinated research. So drafting using AI is not a good idea. And in this, I think there is a need for a collaboration on worldwide judiciaries on AI. Thank you very much.
Thank you, Justice Singh. Just an input to the panelists. If I know even we are brimming with questions in response to your presentation, but use some of the content that you are not able to cover in the course of your time to weave it into the course of the panel discussion. I have lots of questions, but I'll not speak now. Justice Moshmi, request you to make an opening remarks.
Good morning, my distinguished Chief Justices and panelists, and Chief Justices of various courts, judges who are all my friends here. Thank you for making it in the morning. So after Pratibha, I'll just take 3 minutes max to give you a broad overview of what the subject is, which is curriculum globalization and transnational law. I had prepared a PPT, but I'm going to slash it exactly by half so that I just have around 8 slides to show you. And this will just give you a broad overview. So the first slide, which I wanted to show, is increasing cross-border legal issues. And I would classify it into 4 broad headings where actually this global curriculum and transnational issues crop up in our courts, maybe on a daily basis, maybe not. That is commerce, cybercrime, environment, and human rights. And when we talk of rise of cross-border legal challenges, why do we at all need, or why are we confronted with this phenomenon? That is, I don't want to read out the slide, you have it. For those of you who are at the back, I'll just quickly go through what I've written. It's why this phenomenon. So globalization, as we all know, has restructured the international legal border in very fundamental ways, but the two of the most fundamental way is that through the proliferation of specialized international legal regimes in, as I said, trade, human rights, environment, and commerce, and the rising authority, and I would say also recalcitrance, the way the international organizations refuse to follow court orders, or sometimes they are just, they just act difficult, and how to enforce the orders which we give. So these are really, pressing problems which we are facing. And for judiciaries, that's the little footnote in red at the bottom. For judiciaries, this transformation is something which is not an abstract phenomenon anymore, but something which we have not only to look at and in enforcement of international contracts, arbitrations, but also in extremely personal issues, like a child who has been kept in a foreign jurisdiction with the father, the mother has traveled to India, and the child, she's not be able to get back her child. What do we do in those cases? Committee of courts. So these are competing legal considerations which we have to face on a daily basis. So the second part of that discussion would be, as I said, commerce, cybercrime, and environment. And under commerce, we have, I'm not going to repeat because the only thing which is important is to see the rise. And if you see on the screen the first box, that is 19.7% of the world's imports now are affected by tariffs and trade measures, and up to 12.6 a year ago, which is according to the WTO data. And as regards cybercrime, which is the middle yellow box, you'll see that transnational offenses, and we are all familiar with these words, whether it's hacking, whether it's ransomware, whether it's identity theft, or even cyber terrorism. And it kind of all can be traced back to the Budapest Convention on Cybercrime, which was 2001, which was the first really international cybercrime treaty. And then we had the as recent as in September 2024 by the General Assembly of the United Nations, which is the UN Convention on Cybercrime, a resolution, and the first comprehensive global treaty in that way. And when it comes to environment, you have multinational corporations navigating a regulatory, patchwork legislation, a mosaic of legislations with a lot of conflicting interpoints, where the core principle is what we call, it's a trail smelter that goes back to a US-Canadian conflict of global pollution, where the fundamental principle is that you have a duty, each nation has a duty to prevent pollution to a neighboring state, whether by way of organic pollution, whether it's by way of air, fire, river contamination, everything. And of course, soft law instruments, which are full of qualifying statements like if at all appropriate to enforce, whether it is impossible to enforce, etc. So I'll quickly go to, you can see I'm skipping slides, I'll just have another 2 minutes. So if we are talking about harmonization between the Commonwealth countries, then we have to look at two essential subdivisions. The first one would be the Commonwealth Foundation, and what does it have? It has 56 nations, that is the Commonwealth, consisting of about 2.7 billion people. That's a huge component. And 33 small states, which are all united by the Commonwealth Charter. And of course, giving those ideals of democracy, development, etc. And you have a majority of these member states who share English common law foundations, so that kind of binds the common law foundation together. And the interesting thing is where the common law is, has full of conflicts or it's not homogeneous, then it also kind of operates alongside civil law, the statute law of that particular country, and includes Sharia, depending on the population demographic, like in India. And you also have the second column, which is the Commonwealth, which is a shared legal heritage as a platform for harmonization. I'm reading a large part of the slide quickly, though, because I can see that many of you, even on the right side of my, will probably not have access to the screen. So the Commonwealth's legal significance is that, of course, it's not only in terms of size, which is of 56 nations, and of course 2.7 billion people, but it's also the challenge to convert that inherited unity into a kind of a structured, curriculum-driven harmonization project where judges are equipped to deal with complex problems in their distinctive styles. And my next slide is 4 institutions and 1 critical gap. What are these 4 institutions? That is Legal and Constitutional Affairs Division, Commonwealth Legal Advisory Service. You have the abbreviations in the bracket. You have the Commonwealth Judicial Education Institute, and you have the Commonwealth Magistrates and Judges Association. So these are kind of loose bodies which can regulate laws and framework. And what is the gap? The gap is where a lack of Commonwealth standardized framework for judicial education in transnational law. That is what we all need right now. My second slide would be a comparative constitutionalism. Why a comparative constitutional study is required for us who are looking at a Commonwealth as a block of countries and nations. So, and the 3 bullet points basically, that's the Indian Constitution draws, as you know, from multiple systems, and it has bicameralism and rule of law, which is taken from UK. It has fundamental rights and judicial review, which is taken from the US. And from Ireland, we have taken socioeconomic rights and quasi-federalism from Canada. And the need is not to ignore these diverse sources, but also to develop this robust domestic law, which will also help us look at fundamental issues which we are facing in the courts every day. The next part, I just have 3 more slides, is how to integrate international law into the domestic legal education. For judges, legal education is something which we are not privileged with, which we don't have time given the work pressure which we have on a day-to-day basis. But for students and for budding lawyers, for sure, this is extremely important. I'm sure everyone will agree. And that the international law into domestic legal judicial education, that would of course take into account the judicial separation of international domestic law and the critical training gap in judiciaries worldwide, whether it's conflict of laws, whether it's how to give effect to enforcement in transnational crimes, in transnational border disputes, in bilateral treaties, interpretation of cybercrime treaties. These are WTO incentives. What are these incentives, how to interpret, how to apply these incentives on a day-to-day basis. Yes, we have the second, the 2 curriculums. So I've just divided into law schools and judicial academies, because law schools and judicial academies have 2 different complete demographic for its target group. And for technology as the enabler, we have, of course, Swayam, which are online platforms. We have, for judges specifically, we have high courts developing their own online platforms for judges to use, whether it's for judgment writing, whether it's for identifying cases, whether it's for case reference, research. And also the last bullet is the legal research tools which judges need. And I hope, given our work pressure, we can still look at them. Just last slide. So integrating international law into domestic law, there are 5 challenges and 1 conclusion. There are many conclusions. I've just picked up on 1. So the 5 challenges are, of course, extremely theory-based. I'm sorry about this, but doctrinal, the Indian semi-dualist framework. Then there is the curricula, which is the marginalized training, which is sometimes available and sometimes not available in law schools. It is pedagogic. We heard a lot about pedagogic and andragogic yesterday's discussion. It's a lecture-heavy abstract instruction, which is wholly unsuitable for judges. You have political. What is the perception of international law as Western imposition creates institutional resistance, both from our country as well as from the Western and from the European countries in terms of enforcement. And what is the conclusion? It's that a technology-enabled curriculum globalization is the most scalable, cost-effective, and institutionally viable response to a gap which is widening on a day-to-day basis. And my last slide is dialogue in action, which is just 3 key illustrations. First is, of course, now we are 12 years away from that, the Nalsa judgment of 2014, where the Supreme Court drew on Australian, New Zealand, Malaysian, and English jurisprudence alongside ICCPR norms to recognize that transgender persons constitute a third gender, and entirely anchored, however, in the constitutional principles of Articles 14, 15, and 21. And then you have the Avitel Post Studios judgment, which is of Mauritius, which is one of the key players was a Mauritius corporate entity, that is of 2024, where international standards were actually applied to assess arbitral bias. You know, we all know that Section 12.5 and 5th and 7th schedules of the Arbitration Act talks about bias, how to apply bias, but in that case, the courts actually applied what are international principles of bias and what is the threshold for refusing enforcement. This is the last slide, thanks. And the last case is Arif Azim, which is of 2024, that is also the Supreme Court, where in an arbitration matter, the courts took a seat-centric, seat as it's not defined in the Arbitration Act, but seat as we understand in arbitration law, seat-centric approach was confirmed, and the Supreme Court held that Indian courts do not have any jurisdiction over foreign-seated arbitrations, upholding the leitmotif of the Arbitration Act of party autonomy and international commercial certainty. So thank you. That was my opening remarks, and I had to slash it by half, but thank you for a very, very patient listening, and we'll wait for the questions. Thank you.
Thank you. Thank you, Justice Bhattacharya. I'd like to acknowledge and welcome Mr. Venkatramani, the Honorable Attorney General. Maybe, sir, you could give your concluding remarks. We are poised to get into a panel discussion. Or would you like to address us now and then we go into the panel discussion?
Maybe both ways. Can I make some remarks now?
Yes, sure.
I'll go there. I'll do from here.
Yes, yes.
I think I'm better visible there. Can I remote? Yeah. No, not light, sorry. Can remote. My apologies for being late, and this is a subject of long-time interest for me, ever since the National Judicial Academy began paying attention to judicial training. So from the year 92 to 2026, you find many countries across the world are looking at the Judicial Academy Bhopal for a place to go and get trained. But still, I think our understanding of an academy like this to be able to answer many questions, this academy itself has to travel some more distance. Because we have fundamental questions in our mind. When you started with some basic idea of a judicial training, we were in a different social, economic, and political milieu. And the very idea of judges at the higher hierarchy to be trained was somewhat anathema to understanding of the training itself. But I suppose today we have to take leave of that perception and mental perspectives with us. for a number of reasons. And 40, 50 years ago, post Declaration of Human Rights, and the great expectation that the world will move away from dictatorships and totalitarianisms. And as you see, both international financial institutions and other institutions of the United Nations began to drill in, if you may use that expression, different dimensions of rule of law. We have probably reached a stage when nation states are not what they thought will be in the post-colonial era, governed exclusively from within by domestic legal cultures and managed by domestic considerations of social, economic, and developments, political developments. It appears at that point of time we closed our eyes to the potential of huge waves of freedom, free markets, technology tsunamis, and all with the global interventions and global impacts. Nations have decisively moved away from the great appeals of socialistic governance and to experiment with free markets and other connected freedoms. Innovations, major or minor, in all fields of human inquiry, human transactions, and the science technology pushes have led us into social configurations beyond our once comfort zones of domestic policy making or domestic political governance exercises. We no longer have these insulations. Virtually several of our life choices, activities, transactions are now driven and to some extent conditioned by domestically accepted global contributions by way of migration of resources, natural or man-made, financial resources, and human migrations. So it is that we cannot make choices, political, social, or economic, within the cocoons of our national frontiers. Everything is cross-border in several economic and social senses, except perhaps our local body elections and local body functioning, put it at a very ironical level. Maybe even our morning tea shop talks also revolve around President Trump and Iran, besides what actor-turned political leaders are doing to our polity. Cross-border changes and impacts carry with them legal issues and cross-border challenges. Domestic commerce is intertwined with international finance and commerce. They bring legal managements and dispute resolution issues. India has confronted issues in its investor treaty domain, is wondering how to go about the future. Investors want many assurances and returns in matters of tax benefits and less intrusive adjudications. These involve complex political and economic choices. Our domestic laws relating to contracts, exports and imports may not provide all answers to all of them. Besides these national commitments to sustainable development, consistent with domestic calls for realization of an equal status social order. These are emerging frontiers of mergers of policy making, calling for many balancing exercises which cannot be subjected to conventional judicial review tools and doctrines. On top of it, we are confronted with crimes in the cyberspace, difficult to prevent and handle, and difficult to prosecute within domestic frontiers. How can we leave behind human rights concerns which may also take new avatars? So we are in the midst of complexities of phenomena and accelerating speeds of challenges. Our judicial review tools, pressing too hard on conformity with many doctrines and norms, may lead to cracks in the ability of governance. Courts cannot become embedded governance institutions on the one hand, but are persuaded from within to seamlessly transform judicial review into policy entanglements. Without suggesting to be a hint for serious introspection on the quiet assumptions of power and authority by courts, I would submit that the need for a pan-national dialogue on wise management of courts' role in governance cannot be ignored. Lessons from the regime changes, say in Eastern Europe, and the tensions between the political decisions to prosecute communist regime crimes and constitutional court rulings. For instance, in Hungary, Poland, and Bosnia, etc., all those examples are instructive even to stable democracies like India. Comparative law has thus acquired new areas for inquiry. Comparative constitutional law literature has thus bloomed. Academics all over the world are writing about comparisons. Comparisons between comparables and comparisons for the sake of internationalizing constitutional meanings and reasonings. Comparative constitutional theory is again an inviting area of study and exchanges. A recent research handbook in comparative constitutional law, edited by Tom Ginsberg, called Comparative Constitutional Theory, edited by Gary Jacobson, and Comparative Constitutional Reasoning, edited by Andras Jacob, are few pieces of literature in this area worthy of our attention. It seems the traditional lawmaking functioning of courts in statutory interpretation, dressed as the growth of common law, has been necessarily crept into social, economic, and political decision-making, considering them as adjoining areas of lawmaking. I have serious questions and debates open for consideration. We need close attention to all of them, as courts began to fall under pressures of social demands for becoming advisors, Platonic or otherwise. And therefore, in that context, we are talking about, in this context, we are talking about how do we have a global judicial education. We have a wide spectrum of choices and considerations. The fields of inquiry are expanding. And I think our institutions, we need to open up not only our minds for inquiry, but to, I think, as I understand how courts are transforming themselves into deliberating institutions. A lot of ways of looking at them. But how far we can deliberate, where all we can deliberate, and who can enable us to deliberate, and where we have all these, the potentials and the resources for deliberation. I think we're going to discuss all of them today, and the conclave like this will be able to enable very well-informed judges who are assembled here. And we need to take a long vision before we can probably say we've understood everything. And that vision is something beyond what's called, somebody called the end of history. We not reach the end of a liberal state in the world level. For many social, political, economic compulsions and challenges invite us to enter into a very deep discussion on all of this. I'm sure that judges who are here with their experience and managing courts in what's called the challenging ways of fashioning or refashioning judicial review will be able to give us a lot of insights. I'm here ready to listen to them. But only one more concern. The technology intrusions in our life is something which probably cannot take for granted. I think we are ready to grapple the deeper dimensions of all of them. We seem to be receiving them at a very superficial level, taking them for granted. At the same time, I do not know how it's going to be a fundamental part of a life itself. And then if it's going to be a fundamental part of life, whose part of life? Which part of whose life? Is it only the part of the elite, the part of the decision makers, or the part of every section of the community? How are they going to participate in this? When you talk about judicial training, I suppose we need to consider all of them. They are necessarily an integral part of our deliberation. And thank you for your attention.
Thank you, sir. We still have one more panelist, Dr. Kofi Abotsi, who's joined us online. I'd encourage the audience to send in written questions while the session is on, so that way we'll be able to get the sense of the house of what you want covered as well, and also economize on time. Over to you, Dr. Abotsi. Just wait a minute. Just wait a minute. We can't seem to hear you. We'll get the volume sorted. Yes. Yes, could you speak now?
Okay, can you hear me, please?
Yes, yes.
Can you hear me?
You are audible now.
Okay, all right. Good morning, everyone from Ghana. It's a pleasure to join this distinguished audience and speakers on an important topic such as judicial education and the integration of technology, the transnationalization of law, These are very important topics. I would like to just take things a bit from a different perspective because I believe that especially for countries in Africa, the biggest issue is the limitations that are imposed by various constitutions. So if you take the example of Ghana, international law, Ghana is a dualist country, and international law is not part of Ghanaian law in the four and has to be integrated by reason of incorporation. And so Ghanaian judges, for example, cannot apply transnational law. And traditionally, the posture has been against the application of laws that are not part of Ghanaian law or local law. And so there are difficult constitutional questions by way of limitations that Ghanaian courts confront whenever they have to resort to the application of foreign law. I would say, however, that Ghanaian law, for example, allows the application of customary international law. And so where you have a treaty position, which is deemed as not having been expressly incorporated under Ghanaian law, the judge's fallback will be to establish that a particular position is found or finds expression under customary international law. And so as I listen to some of the presentations, especially Indian and Sri Lankan judges' application of, for example, international treaties, the question I asked was whether under Ghanaian law this could have been applied if, for example, they have not been expressly incorporated into Ghanaian law by Parliament, and Parliament is the legislative body, by Parliament expressly passing a legislation that makes it local law. From the standpoint of academia, someone who's in academia, and the teaching of judicial application of legal principles in Ghana, I think I'm looking at these things more from a problematic perspective because of the long-standing judicial cultures and the tendency for courts across the Commonwealth, broadly speaking, to want to restrain themselves from applying decisions that have been adopted in other jurisdictions. I think the first difficulty that we would have to confront is the question of judicial politics. What are the metrics for selecting particular decisions from particular jurisdictions and not others? If, for example, you have competing decisions from jurisdiction A and a contrary decision in jurisdiction B, what, for example, will inform, say, an Indian court or a Ghanaian court for preferring a decision in jurisdiction A as opposed to jurisdiction B? Now, the reason this becomes important is because we do not have legal ordering between these countries. And so while, for example, in Ghana, we can have a structured arrangement of the various legal orders, and so a court may apply a particular decision on the basis of the superiority of the jurisdiction of a particular court and a lower court. If you have a decision of another country's court, there is no such superiority ordering of norms. And so the court will have to make a choice between competing jurisdictions and decide that they prefer a particular decision in one particular country and not another. These may lead to normative choices that can be contested and implicate political considerations. So that's one difficulty, for example, that I reflected on as I decided to speak on this topic. Of course, this therefore speaks to the question of horizontal and vertical relationship. Do countries, of course, relate on the basis of horizontal relationship? There is no such vertical structure between countries in terms of jurisdiction because there's no such relationship. So that's one difficulty. But the other difficulty is the traditional and long-standing one. The countries of the South tend to relate more with the countries of the North, and they tend to prefer countries of the North in terms of the decisions of the courts of these countries. Perhaps this reflects the long-standing perception that the institutions of the North are more developed than those of the South. And because Northern institutions are more developed than those of the South, and because from a legal tradition perspective, we have inherited our legal traditions from colonial powers, and we have modified them under different circumstances till today. But the broad outlines still remain what it is. And so common law countries share that perspective. But countries, for example, in Africa may probably just refer to decisions of an American court in the explication of their constitutional norms, perhaps more than they do refer, say, to Indian decisions. And I have to say that is changing very quickly. Actually, in the case of Ghana and in the case of many countries that I'm aware of in Africa, Indian decisions are more appealing when it comes to the explication of constitutional norms lately, partly because of the similarity of circumstances. But generally, that perception or assumption that northern countries tend to have stronger institutions and their norms are more developed leads to a situation in which there's more reference from south-north as opposed to south-south. I think that dynamic is also important to bear in mind as we think of the globalization of legal norms. Because in truth, in my opinion, there does not appear to be such a globalization, but rather the north-south divide relationship has informed the references to judicial decisions as we explain our norms. And for students of constitutional law, it is clear that from from principles of judicial review, among others, there's more preference for the decisions of courts from the north than there is for those of the south. So I'm not sure how much time I have, but I think I would just like to conclude by saying that.
You have about a minute.
I'm sorry?
more. 1 more minute.
1 minute.
Yes.
1 minute. Okay. So I would just like to very quickly conclude, by focusing, for example, on the broad principles that inform constitutional practice, for example, in the case of Ghana, and how that impacts judicial decisions when it comes to the globalization of law. And I think the key one here is the issue of limited governance. Because limited governance informs constitutionalism in this part of the world, everything courts do would have to be situated in the context of justification. And the difficulty of justifying references to foreign norm remains the contested area, particularly if, for example, you have an electoral petition pending before the Ghanaian Supreme Court, in which a decision will result in the formation of government. You may be in very hot waters if the fundamental decision around which, the fundamental case around which a decision is based is foreign law. That might result in all kinds of contestations that would implicate other controversial subjects such as corruption, judicial preferences, and judicial politicking, among others. And these are, I think, some of the considerations that tend to limit or restrain judges as and when they think of referring to a foreign law, even if that foreign law is fundamentally persuasive from the standpoint of principles. Thank you.
Thank you, Dr. Abutsi. We'll now dive straight into the panel discussion. Over to you, Ms. Fartal.
Our distinguished speakers and panelists given us a lot to think about. So what we're going to be doing next is asking some targeted questions based on the themes. So my first question is, as the cross-border disputes increases, how can judicial training help the judges handle issues like commerce, environmental law, human rights, cybercrime, while staying grounded in domestic law? So this brings us to the question whether there is scope to tap into synergies among Commonwealth jurisdictions. I would like to address this question to Honorable Mrs. Justice Maushami Bhattacharya, Judge of High Court of Telangana.
Thank you, Meera, for that question. So, three broad divisions. One is commerce, one is cybercrime, and one is environment. So, when we look at commerce, then we are looking at contract breaches. We are looking at IP violations. We are also looking at regulatory conflicts and something more specific like intra-group transfer policy disputes, and also trade-related disputes. The judicial gap, which I feel, at least what I have felt in my court, is we have maybe a basic awareness of that, now we are kind of global citizens, but we also have a structured statute in front of us. We have a statute to follow, or we have other statutes which we keep on the side as incidental references. But we also don't really have the time the time bandwidth, I would say, where we have, like a knowledge base of what, for example, the WTO regime now says about, bilateral treaty disputes, about trade-related regulatory disputes between two countries. What are the emerging digital trade norms which we should be aware So I think that judicial curriculum, when it comes to commerce, we should look at, not only conflicts of law, but very definitely private international law. And as I gave that example in my opening remarks, when a parent leaves a foreign country and comes to India, whether by reason of a divorce or separation, and the child wants to be taken back by the other parent who's in the USA, and if we go on passing orders, what about their enforcement? What about the extent of which we can pass orders and ensure that those orders are implemented? At best we say, okay, so why don't you go to the local jurisdiction, to the jurisdictional court and file a guardian and wards OP and seek relief of custody. Even if that is done, what is the power of the court, particularly in a habeas corpus writ petition, where the jurisdiction is extremely limited, and we can't go to the extent of deciding the rights of custody. I think that's a gap or a need where judges should be given some sort of a training in private international law, a structured training on treaty obligations. We all have a loose idea that India is not a part of the Hague Convention, but then because India is not a part of the Hague Convention, what is the fallout of that in a bad way, and what is the advantage of that as courts, as judges of courts sitting in India? So in relation to cyber crimes, as I said, that we are all aware of these trans-border, boundless internet's borders where crimes are committed. And forget about Jamtara, forget about localized hotspots of cyber crime, but what about cyber crimes, hacking, identity theft, ransomware threats? Because this is given to a potential evolving threat landscape, if I can use that word, where we have to be equipped with that knowledge as to how to handle these kinds of cyber arrest, digital arrest, cyber terrorism, how to deal with this. And if we look at the Budapest Treaty on Cyber Crimes of 2001, followed by the Law Commission, Indian Law Commission took it up in 2019 as the first comprehensive cybercrime perspective of Indian law, and then the recent UN Convention on Cybercrime, which is of 2024. But we still find that it's a fragmented world when it comes to enforcement of these, how to, for example, look at digital evidence standards, authentication and admission of digital records. How to, if you have a criminal case, how to, are there any uniform norms as to whether you will admit a certain digital evidence or you will not admit, or how to interpret cybercrime treaties and data convention norms, theft of data. These are very pressing issues. And I'll quickly go to the last one, which is environment. Environment, I think, is one area where we are really kind of lagging behind. And I can only speak for myself and not about anyone else over here. But I feel that my knowledge of where environment is moving in the international sphere is very limited. I know some small little attractive sentences like this, the trail smelter principle, which is basically a duty to prevent trans-border harm. And as I said, it was a case between US and Canada. But we are all very alive to river contamination. We are alive to noxious gases. We are alive to organic pollutants. Where the states, we have the artificial boundaries, but can we control these pollutions from transgressing the borders and entering the neighboring state? And if the neighboring state files a complaint against the originating state, then what are the laws which we can apply to prevent or bring that offending state into some sort of an obligation? And there, I think the international principle, I just looked at some, just 3 or 4 treaties, where the words used are, I'll just tell you, as appropriate, to the extent possible. It is an endeavor to prevent trans-border environmental harm. So basically, these treaties are rendered toothless Because the moment you say endeavor and to the extent possible, you're basically not bringing the offending state down to its knees and ensuring obligation or the way of imposing penalty. What kind of penalty will that offending state give? So I think this is a kind of a curriculum which is calling for some sort of a structured teaching and training for judges, where as soon as the problem comes before us, we have at least an awareness, if not a dedicated knowledge base, or at least we can ask the lawyers in front of us that, okay, you show me this, or there's a treaty to this effect, or there is an international norm or an act or something, so you can show this to me, show these provisions, look it up, assist me, assist the court. So even to ask those questions to the lawyers, we need to be aware that there is, an approach, a database, a knowledge base which is available, which we can tap into. Thank you very much.
This brings me to the next question. While harmonization is important, while one examines universal principles, as I said, greed and fear drive drafting of law, law ultimately is a byproduct of political science and behavioral economics. That choice is made by each society in the manner that that society feels fit. For example, compliant child disciplining in India or China or Asia may not be consistent with compliant child disciplining in the US or Europe. So where does one draw the line? There are some questions also from the audience. Nobody teaches comparative law in law school, but when that's brought into the courtroom and decisions show comparative law across the board, including commercial laws, where does one draw the balance between balancing a universal harmonization with conscious policy choices each society makes? I'll address this to you, Justice Singh, but as I said, I'd invite everyone to chime in, including the chairs, with your experience from your respective jurisdictions. Over to you, Justice Singh.
I don't think I need to repeat this, but the Constitution is our Grundnorm. Article 51 clearly says that we have to foster respect for international law and treaty obligations, and it's part of directive principles of state policy. So it is not a mandatory thing for courts. Our policy has to be as per our socio-cultural and economic needs. And I can just give two illustrations which would maybe help us understand this. Let's go to one extreme, let's say abortion. India has been a very forward-looking country from 1971 to give women the choice, whereas the US has taken a completely different stand right now. There cannot be harmonization when there is clear domestic policy law to that effect, which is to the contrary or even showing a different direction. Again, let's come to another law which I'm passionate about. Like in the patent law, when we came to the Novartis case, cancer drugs, whether additional formulations, additional molecules, additional polymorphs should be given patents or not. We have a specific statute under Section 3D of the Patent Act, which said only one time the patent will be given, no evergreening will be permitted. So irrespective of whatever TRIPS obligations may say, as long as the constitutional validity of that provision is there, we have a duty to implement that. So as a judge, I would think there are only 3 steps. I would call it the ladder, the transnational ladder. Let's first see what is our domestic law. Let's then see what is the international treaty or the agreement or a prevalent position which is placed before the court. Then we'll have to first check whether that particular international position matches with Indian constitutional principles and statutory principles. Even if we see a slight conflict, we cannot apply that foreign law. But yes, where there's no conflict, we do have the famous gramophone company case of the Supreme Court which says once treaties are there and India has not made a municipal law to the contrary, then of course we can always implement that principle if there's no contradiction with Indian law.
I think Justice Govindan, you had something to say.
on all this, I take a broader historical perspective. We were all segmented once. You know, we were all a very small jurisdiction, pre-colonial, each of us having our own laws of our own, not touching each other. And then suddenly there were boats from Europe going everywhere. And with them, their colonies, they brought their laws. They to India, to Seychelles, to Africa. And for a while it stayed, but after a while we said, no, we need our independence. And colonialism stepped in. Strong colonial will to make our own laws different from the rest. But increasingly we're seeing that, no, we cannot. No man is an island. The way things are moving now, whether you are monist, you are dualist, or whatever, the amount of information in terms of coming into our country through our citizenry, in both form and substance, in format, is so overwhelming that eventually, I'm very optimistic. There will be one form of international standard that we need to approach. We know we have our constitution, we know it's sacrosanct, it's supreme, but eventually, the human race is going in this direction. So, whilst we are interpreting the law in terms of harmonization, we have to have this in mind, that we cannot remain segmented. We need as much as possible bearing our national policies, our constitution, our values, increasingly integrate the values of this world when it needs to bring justice to the case. You see?
And we also have the complexity of the economic colonizer feeling colonized and unleashing tariffs, for example.
Yes, so it's the reverse now.
I know it's a very optimistic tone, but we do need, this needs to come into the curriculum. Because very often judges, there's another question from the audience along those lines. How does a judge react to geopolitics? Should a judge at all react to geopolitics? Or should the judge be totally blind to a geopolitical situation? For example, we get interim relief applications in connection with a ship which couldn't dock because it couldn't get insurance in the current situation. And the arbitrator says, sorry, I'll give you no protection. And they come and say, you have to be alive to the equity of the situation and make an intervention. So where does one occupy the space in providing training for this is something I want to leave behind if anyone has thought about. Yes.
Let's have some clarity on what we need to do by training, right? Do we have the freedom as a political thinker or a political strategist, in which case you have the entire canvas open before you, or we have to think in terms of institutionalizing certain phenomena we notice across and bring them in conformity again with certain fundamental norms and provisions and things like that. Therefore, I say if in the context of the three-tier freedom you have to look at international law, suppose I challenge that it's all very traditional, conventional. Today, this traditional, conventional way of incorporating or borrowing international law seems to be breaking down somewhere. At one level, I would say conflict of laws are all colonial products. They were all thrust upon us. Somebody said, well, my law will prevail. Then, if you look at even the international commercial developments, WTO has almost come to a breakdown point. So, who commands power at the international level? And so who dictates what will be an international norm? And which international norm can prevail with us? These are questions which cannot be answered purely in terms of legal principles. But legal principles will probably receive some kind of a shadows and from political understanding. Therefore, today you're in a very peculiar situation of a mixture of political theorizing and international normatizing. So this is a very peculiar situation. It's in that situation I think we need to have critical studies. Right? Critical studies like CLEA, we have the International Law Commission, which again works under all kinds of international compulsions. Who decides what are important for the international community, regional, several continents, Asia, South America. So what kind of interests are important for each country there? So we don't have an international law commission body which can address regional concerns. It addresses some broad areas, but we need to have that kind of a body. If probably we can create a body like that within the CLEA and says we'll produce a critical legal literature which will look at what kind of critical dimensions are required for us and then outline a curricula for judicial training, that will be important for us.
Yes, yes, sir.
I think working on what you said, the Honorable Attorney General said, we mooted this recently. In fact, when delegation of Sri Lankan judges met with the Chief Justice of India.
A small interruption, Judge. Judicial lawmaking, unlike a common law growth, which you had leisurely pace, today can become little ad hoc and probably cannot probe the various dimensions where it can lead to. Therefore, the institutional structures of courts do not really enable you to go beyond ad hoc understanding. That's where the challenge lies.
I think we must have constant judicial dialogue among the judiciaries. That's, I think, the desideratum. The meeting of the judges must take place. Maybe CLEA and other institutions must promote that atmosphere. Then we come to grips with what is happening around us. So this judicial dialogue is the need of the hour. In fact, we mooted this recently, and the Supreme Court of India did say that we should have a Southeast Asian or South Asian Institute for Comparative Legal Studies or Legal Jurisprudence, so that we bring all the judiciary under one umbrella, and then neutral citation is maybe, you do neutral citation, Sri Lanka, we don't have neutral citation, to be frank. So when we get to that, how India is reacting to it, and other countries are reacting to it, then we take to water like duck takes. So this kind of ongoing dialogue must take place. And as my friend said, the monism and dualism, this boundary is breaking down. Even though we have allegiance to the constitutional precepts. What you said, Justice Pratibha Singh, this same provision exists in our constitution as well. But in a recent case that I decided, I made a private actor liable, but even though the word state is there, the state has to be part of it, but I said the private actor has to respect the soft law instruments, such as, I relied on soft law instruments. Multinational companies, it was a multinational company located there, which had, and two petitioners came and argued the case unaided and unrepresented in court. So when I thought I should award them relief, and when I awarded them relief, the costs were imposed. A huge amount of compensation was imposed on whom? On the private actor, which was a multinational company. I did it in the FR jurisdiction, fundamental rights jurisdiction, a little bit of innovation. I looked at the UN treaties on UN convention, Human Rights Council conventions, on the liabilities and obligations of multinational companies and businesses. One of the lawyers who read the judgment came up to me and asked me, "So how did you get this?" So I told him I came across this when I was going to Geneva some time ago, and I picked it up. So this ongoing legal awareness and education are a must among the judiciaries. The curriculum must equip equip us with this sensitization of these illegal issues. Only then we can take it forward. Otherwise, our growth will be stunted.
Just seeing you had a quick 2-minute intervention.
Yes. Justice Govindan has actually shown us what could be utopia, which is very difficult because, of course, we would all like to have one law, one socio-economic situation in the whole world, but it's not like that. And therefore, I do think that the learned Attorney General and what Justice Nawaz said in terms of informal dialogue is the through good bodies like CLEAR or even the World Intellectual Property Organization. I can just give a very small example. They have a forum for judges which meets and also has online webinars, and you will realize that many countries from Africa, Southeast Asia, Philippines, Vietnam, etc. look for India for guidance on intellectual property now. And therefore, informal dialogue, meeting, collaboration is how we can achieve some level of consistency among judiciaries, and forums like these are the ones which can actually promote this, and Justice Mushtaq has made his first step towards that by having all of us here today.
You permit me to give an example. Last year when I was at the G20 Prosecutor General Conference in Brazil, so at the end of the conference, some of us thought, we have the International Criminal Court. We have problems of jurisdiction in cyber law and many things like that. So why don't you have institutions like ICC at regional levels? And we look at jurisdictions, we are able to resolve those problems through a common global understanding. But how do we move towards them? I think all these engagements, a judicial training, a judicial colloquium, I think will push the agenda forward. I thought I'll share that illustration with you.
I was a bit idealistic, but this is the mindset that we should have, right? That the belief that there's need for proactively considering the issue in depth is there. And the question is what forum, international or local, that needs to take place.
Now that leads us nicely into the next question about comparative constitutionalism. So how can the principle of comparative constitutionalism meaningfully integrated into the curriculum while remaining consistent with any particular country's or jurisdiction's constitution? So I would like to know what the panel believes. What should we watch out for when we talk about the best global practices in judicial trends? I would like to address this to Professor Abotsi, Dean of UPSA Law School in Ghana. I would also like to request at the same time if we could constrain ourselves for 3 to 4 minutes response, that would be great. Professor Abotsi.
Well, thank you very much. I wish I could hazard a standard question, a standard answer to this. I think it's a pretty much evolving area, and it would be helpful if courts perhaps adopt a Latimer principle style of standard rules that could guide courts in the ascertainment of foreign law and in the application of foreign law. As I indicated, for a country like Ghana, and I'm sure many countries face similar circumstances, there is already a serious difficulty with judicial politics, especially at the apex level. And I have, not so much, but reasonably followed the Indian Supreme Court's, jurisprudential culture. And I know how contested some of the issues are, from matters bordering on religion to governance. Everything can be extremely vituperative. So if one is not careful, it is very easy for courts to fall into the abyss of accusation of dabbling in judicial politics. I think the best way to go, especially for courts to avoid some of the consequences or difficulties of applying foreign law and the accusations that come with that, will be for an adoption for some standard guidelines, similar to what has been adopted on corporate governance, what has been adopted in various aspects of the law within the Commonwealth. Perhaps that could be a good starting point that would help courts to synergize and to standardize the principles that guide the application of foreign law. I'll just leave it here for now.
Thank you, Professor Abotsi.
Thank you. I think that's all we have time for. Well, we have some time for the discussant. Sumit Bhattacharya to summarize things. Oh, you have something to say? Yes.
Just 1 minute. It just struck me now, through this conference, that the National Judicial Academy, we have a discussant, we have Shruti right there. If we can, since we are talking about the Commonwealth now, but if we can have some sort of a training module, structured training module on common behavioral patterns behind certain kinds of crime, whether it's cybercrime, whether it's information hoarding, whether it's insider trading, and what are the common behavioral patterns which lead to these kinds of misconduct and wrongdoing, and what kind of really drives people to commit these crimes, and if we can have a related module on aspects of witness protection, plea bargaining, sentencing, dealing not only with India, because we have our statutes in place, but in a block of Commonwealth countries and an international forum, because that will be a very interesting way of, looking at a perspective of crime and criminal behavior which transcends borders. So I just thought I'll give this suggestion. Thank you.
Thank you, ma'am.
It's good that we have the National Judicial Academy represented here as a discussant. So I'd request Sumit Bhattacharya to summarize some takeaways for your work in the Judicial Academy. And since we have Chief Justice Mushtaq now here, on behalf of the entire panel, I also want to thank you for organizing this seminal discussion and getting us to Sikkim on Buddha Purnima. So we meditate on these very important facets. Sumit Bhattacharya.
Thank you, sir. Thank you for giving me this opportunity, Mushtaq sir, to be here, and respected Presidium on the dais, and all the dignitaries of the dais. I am a discussant. I want to just float a couple of points and keep it very crisp. I take from Justice Maushami, who has succinctly put a couple of things to be done by the Judicial Academy. Probably we are working on that. And we have something which is not only judicial but extrajudicial, which works out on the behavioral patterns. We had been doing about sessions on stress, which is not something which is judicial, but it transcends all borders. It's a human thing. Keeping that, just coming down to the wonderful discussion which took place, a couple of questions which came through, and the value and the depth of jurisprudence which was being exchanged here. To take it forward and sticking to the topic assigned, what I thought that curriculum globalization to enable the transnational laws, quick few points which crosses my mind is like, today's world, the judge's judicial function is no more in silo. It is embedded with a lot of technological aspects. We never got a tuition to use a smartphone. We did it as we are all doing it. And so in that way, I would say that there are two sets of things which are there. One is a legal problem having a technological issue which we can, or a technological solution which can bank upon. Very simple, like we take our smartphones to protect our privacy, we can go use the biometrics and passcodes. So those are small tips, but definitely to top it all, we can have a human on top of it if something goes wrong. So human in the loop remains there in a crisp way. The other thing is that technological issues having legal solutions, which we deeply delve into. So such kind of things are there. And this leads to the second point, that in this techno-legal arrangement or walking into the AI ecosystem or most modern technological ecosystem, there are challenges like within, not transnational also, it is intranational also, like militating constitutional rights cropped up, such as our right to privacy heads a loggerhead with our right to freedom to speech and expression, right to be forgotten, that crops up. To what extent? These are the areas which definitely a curriculum might be thinking to, we are thinking on those lines to have sessions on them. So the challenges are many which should be found, like if we see a child discussing with a chatbot, and the chatbot, which is largely unregulated, and it's a private entity thing, it actually inspires a child or abets a child to even commit a suicide. Or a chatbot gets so friendly to a person who is fighting solitude that the person gets married, gives a proposal to marry a technology. So those kind of things are coming. What Shruti said last time, yesterday, something which is happening in the virtual world, like we can have games, a boxing game, where we actually do not physically get hurt, but definitely there can be a thing which can be coming to you saying that, yes, it is impacting, what are my rights? So those kind of things come up. The third point is like where we do not have control, where there is no human intervention. Like, for example, I'm not sure whether all of us have heard about vibe coding, where we do not require a human coder to code. It's an algorithm which codes for you. And that algorithm codes for us something which actually lands up into a fiasco. How do we deal that? Or an agentic misalignment happens. Like some of us might have heard about it, wherein AI goes rogue. It doesn't obey what it is coded for. So how do we deal that? So those forms part of the curriculum. And coming down to one very important part, that is we had been thinking about borrowing the foreign jurisprudence, the foreign wisdom, as many of us have discussed. But what about the dissents? Dissents are great resources and potential which waits. And to point to one thing, like there are dissents of one nation borrowed by other nation. And I'll just crisply give a couple of such examples. Jackson versus Metropolitan Edison, Justice Douglas in '74 gave a dissent which was borrowed by R.D. Shetty, International Airport Authority in '79. Similarly, Satwant Singh Shawnee versus Ramnatham, 1967, Hidayatullah Justice gave a dissent which was being borrowed by Malaysia in Loh Wai Kong versus Malaysia. Thirdly, Liversidge versus Sir John Anderson, the great dissent of Atkin, borrowed in several cases. So dissent are largely ignored. So if we can indulge into taking this resource as one of the potential for judicial education, I thought this would be there. And coming down to one more point is like Commonwealth countries, as Justice Maushumi was projecting, we have two things. One is, none of the Commonwealth countries we have root servers, the controlling servers. There are 10 or 12, majority with US, one with Europe, and one with Japan. So what happens is at the same time, parallelly, we are the biggest population, 2.7 billion. So what happens is we are the great data producers. This data, which is the new oil, is a wealth, and it is being controlled by the countries having the root servers. So in such cases, the liability of the ISP, as we have been proudly advocating and changing the jurisprudence, better to be done by the judiciary, because we respond very fast than the legislative. Here, the jurisprudence of judicial activism may work out more, because we have seen in the January or February a couple of cases from the Central Consumer Protection Authority in case of Amazon seller, wherein the GPS and the drone jammers were being sold. So Amazon stopped, and I'll just take 30 more seconds, and thereafter, we are actually transiting from a caveat emptor position to a caveat vendetta, where just the noticed and pull-down design, which is reactive in nature, should be boiled down to a new jurisprudence or doctrine of gatekeeping of proactiveness. So that is what judiciary should be thinking. So my last final words, that can we take this a proposal before all of the learned judges here that we should go local. Let it be global, but yeah, employ it locally. So that's what I thought should place before you for your considerations. Thank you.
Thank you to the Honorable Chair, co-chairs, esteemed panelists, moderators, and discussant for such an enriching and engaging session. Now we will have a short break of tea break of 15 minutes. But before we proceed, I humbly request all dignitaries to kindly assemble for a group photograph. Quick group photograph. Hello, check. Welcome back, ladies and gentlemen. With the kind permission of the chair, I shall now take a moment to introduce the distinguished dignitaries presiding over and participating in this session. As a token of our love, respect, and appreciation, I request Learned Deputy Director, Madam of Sikkim Judicial Academy, to kindly offer khadas to our respected dignitaries. We are deeply honored to have, as the chair of this session, Honorable Mr. Justice M.S. Ramchandra Rao, Chief Justice, High Court of Tripura. We are privileged to have, as the co-chair, Honorable Mr. P. Sam Koshi, Judge, High Court for the State of Telangana. Our esteemed panel comprises of Honorable Mr. Justice D.K. Singh, Judge, High Court of Karnataka. Honorable Dr. Justice Kausar Edapagat, Judge, High Court of Kerala. Barrister Prashant Barua, Barrister at Law, United Kingdom, and Executive Member of Commonwealth Legal Education Association. Professor Stephanie L. Shallow, Head of School of Law and Professor of European Law and Reform, University of Centre, Lancashire, Cyprus, is joining us virtually for this session. We are grateful for your presence, Professor Stephanie, and thank you for joining with us for this session. We are honored to have our moderators for this session, Honorable Mrs. Justice Soba Anama Apan, Judge, High Court of Kerala, and Dr. Giri S.S., Vice President of Commonwealth Legal Education Association, Asia. The discussant for the session is Dr. Ruchi Sharma, Joint Secretary, Commonwealth Legal Education Association. With these words, I now respectfully invite the moderators to kindly commence the proceedings.
Good morning. Am I audible? No. Am I audible now? Yes. Good morning, everyone. We ought to have started the session by 11:15, but it's already 11:45. We have to wind up the session by 12:30 because the valedictory function is at 1. We all have to reach the main venue. So I did not delay. And here today we have a very eminent and vibrant chair, co-chair, and panelist. And happy to have the co-moderator as well as the discussant. So topic for today's session is digital challenge in judicial education, cooperation across the Commonwealth. Judicial education is undergoing a profound transformation. Across the Commonwealth, we are seeing both remarkable innovation and stark disparities, particularly in digital infrastructure, access to knowledge, and the ethical use of emerging technologies like AI. Today's discussion is not merely about identifying challenges, but about exploring how cooperation can help us bridge these gaps and build a more connected, future-ready judicial ecosystem.
So we moderators have planned to give opportunity to the chair and co-chair first, but it would be around 5 to 7 minutes. And then we'll directly go to panel questions. So, and they can take 3 to 5 minutes maximum. And if there is any questions from the audience also, it can be for another 1 minute as well. So I invite the chair for sharing the thoughts.
Distinguished fellow panelists, the Chief Justice of Seychelles, Sri Roni James Govindan, the Chief Justice of Delhi High Court, Justice Upadhyay, judges of these high courts who are all present here, learned Attorney General, Judicial Academy directors, educators, ladies and gentlemen. Judicial education is a specialized area in which law and education intersect. Its development and acceptance in the judiciary is relatively new. But it has become a critical component for any judiciary wishing to perform at its optimum in the proper administration of justice. It has not remained confined to conventional pedagogical methods. It has been accepted for some time that if justice systems are to remain credible, efficient, and humane, judges must be equipped not only with legal wisdom, but also with digital competence. There is a great importance in sharing knowledge in judicial education. There is a constant flow of new ideas and explosion of information from various sources useful to judicial officers and to persons in court management and administration. It is important to identify among this vast amount of material what are relevant and useful for each of the several jurisdictions, and after such identification, to disseminate these ideas and information to all those who would find them useful within the respective judicial systems speedily and without much cost. As we are all aware, judgments of the US courts, courts in the United Kingdom, Australia, and Canada on various topics such as judicial review, commercial laws, including arbitration, human rights, environment laws, have been in the past and are even now referred to in Indian courts, including constitutional courts, and have many times been applied. Likewise, concepts like the public interest litigation used in India, USA, and South Africa are creating interest in other jurisdictions of the world too. Even systems relating to administration and court management by using particular technology can be useful for sharing. Ideas tried and tested in one jurisdiction are being shared through the judicial academies imparting judicial education. Technology has a very important role in the sharing of judicial education too. Technology can be employed in judicial education in the use of simulations, problem-based learning, role-playing, and digital tools of engagement like polling, breakout rooms, AI-assisted learning. A study by the Center for Research and Planning of the Supreme Court of India in its publication, Rethinking Judicial Education, called a detailed study of curriculum and learning methodologies in judicial education, recommended setting up of a cloud-based learning platform and e-knowledge platforms or e-learning platforms with documents, repositories of research articles, and sharing of ideas and opinions by peers and colleagues in judicial academies. These knowledge-sharing platforms can become instrumental in learning and answering queries regarding judging. In this endeavor, the Commonwealth, with its rich diversity of legal traditions, shared constitutional values, and enduring commitment to the rule of law, can effectively act as a platform for cooperation, mutual learning, and collective innovation. But there are certain problems, such as disparity in technological infrastructure even among the Commonwealth nations. Some jurisdictions possess sophisticated e-filing systems, digital case management software, AI-assisted legal databases, and seamless virtual hearing facilities. However, some others continue to confront issues of limited internet bandwidth, inadequate hardware, inconsistent electricity supply, cybersecurity vulnerabilities, and insufficient digital literacy among stakeholders. Such disparities create a serious risk of uneven justice delivery and fragmented judicial learning. If judicial officers in one jurisdiction have access to advanced digital tools, while their counterparts elsewhere struggle with basic connectivity, the promise of equal institutional advancement remains unrealized. The answer does not lie merely in financial investment. It lies equally in cooperation at the international level, where technologically advanced jurisdictions mentor and assist emerging systems through grants, open source solutions, technical training, and institutional partnerships. At this juncture, shared progress ought to become the guiding principle. One of the other challenges is regarding access to knowledge. Judicial education depends upon quality materials such as precedents, comparative jurisprudence, ethics modules, sentencing principles, cyber law updates, case studies, and continuing education resources. Unfortunately, such materials often remain dispersed, inaccessible, or limited to individual institutions or jurisdictions. In this state of affairs, it is imperative to create a Commonwealth Digital Judicial Knowledge Repository. It would act as a secure and curated platform, hosting judgments of significance, research papers, training videos, webinars, model curricula, and multilingual learning modules. Such a repository would democratize access to learning and reduce duplication of effort across institutions and jurisdictions. It would immensely help in judicial decision making. Similarly, a Commonwealth Judicial Learning Portal may be developed to provide online certification programs, thematic short courses, and live lectures by eminent jurists. It may also act as a discussion forum for judges and judicial educators. Such shared learning can enrich every jurisdiction. The emergence of artificial intelligence brought with it both opportunity and caution. AI tools can undoubtedly assist with case management, automated documentation, and legal research. AI platforms such as SUPACE, that is the Supreme Court Portal for Assistance in Court Efficiency, uses AI to assist judges with case analysis, legal research, and managing large volumes of case data. AI can assist judicial education too in remarkable ways. It can organize case law, summarize precedents, identify comparative jurisprudence, translate materials, personalize learning pathways, and simulate courtroom scenarios for training purposes. It can significantly reduce the time required for legal research and enable judges to focus on analysis and reasoning. Training sessions can involve demonstrations of how AI tools can automate repetitive tasks like sorting case files, tracking legal precedents, generate summaries. However, AI must remain a servant of justice, never its master. The reason is machines may process information but cannot replicate conscience and constitutional morality. AI systems are driven by algorithms which may reflect inherent biases if not carefully designed or monitored. Therefore, training should include discussions on how to detect and mitigate bias in AI tools, ensuring that AI-driven recommendations do not infringe upon the principles of fairness and equality. There should be human oversight in judicial processes, as AI should serve as an aid rather than a substitute for judicial discretion. The European Union Artificial Intelligence Act 2024 establishes the first comprehensive legal framework for AI in the EU, promoting trustworthy AI while safeguarding fundamental rights and public safety. It adopts a risk-based regulatory framework that classifies AI activities into 4 categories: banned, high risk, limited risk, and minimal risk. Notably, the deployment of AI for legal research, interpretive assistance, and the application of law to facts is designated as high risk. Reflecting the sensitivity of adjudicatory functions, the Act mandates meaningful human oversight wherever AI is used within judicial processes underscoring that technology may assist but cannot supplant human judgment. Even when such requirement is enacted as a law or mandated by rules of practice, ensuring that there is adequate human oversight to not undermine application of mind by judges is difficult. Commonwealth cooperation should also prioritize the responsible integration of AI into judicial training. In this regard, shared guidelines may be developed on the following areas: use of AI for research assistance only, safeguards against bias and discrimination, confidentiality of judicial data, human oversight in every consequential use, and training judges to critically evaluate AI outputs rather than blindly rely upon them. The next important issue is the ethical framework for technology use in courts. Technology without ethics may erode trust rather than strengthen justice. Courts occupy a sacred institutional space because of public confidence on their impartiality, dignity, and integrity. Therefore, digital transformation must be accompanied by robust ethical frameworks. It is hardly possible for any judicial academy alone to meet the accelerating demands of technological change. Institutional cooperation is therefore indispensable. I suggest that there should be short-term, mid-term, long-term goals to be set and periodical progress assessment to be done. These efforts would prepare judges of the Commonwealth jurisdictions not only for the regular court work of the present, but for the constitutional challenges of tomorrow. Thank you.
Thank you, Chair. I invite Co-Chair for giving valuable suggestions.
Respected Chair, esteemed panelists, the dignitaries of the dais. The topic for the day for us to deliberate upon is the digital challenges that we face in the course of the justice delivery system. And we also need to keep in mind the challenges that we face, particularly in the Commonwealth countries. As we all know, digital challenges and the judicial education across the Commonwealth have become more visible as the courts have been increasingly relying upon the technology at every stage, be it the administration, be it the hearings, recording of evidences, record management, and public access. Judicial institutions, judicial academies, training institutions are all under tremendous pressure to prepare the judges, the staff, and all connected to the judicial system, not just in the use of digital tools, but also to understand how the digital process interacts with fairness, due process, open justice, and institutional legitimacy. One of the foremost difficulty that we face today is that it is not, the digitalization is not just a single reform that is to be taken. It is an ongoing transformation at every stage, and we need to update ourselves on day-to-day basis. One of the foremost challenges that we face is the uneven availability of digital infrastructure across the country, India, as also in the Commonwealth jurisdiction. Some have robust ecosystem with stable connectivity, integrated filing system, and digital archives, while others still depend heavily on the traditional paper filing and the manual method of practice. Closely connected is another challenge of the digital divide among the learners themselves. judges, magistrates, court staffs vary widely in digital literacy, particularly where judiciary includes a mix of new recruits and long-serving officers trained in the traditional system. A major operational challenge that we face is the absence of standardized digital competency frameworks. While Commonwealth countries often share broadly legal traditions, their courtroom rules, procedural requirements, and technological platforms differ from country to country. One jurisdiction may use a well-integrated electronic case management system, while another may have a partial digital limited to scanned PDF formats itself. Another pressing challenge that we face is that of cybersecurity and data protection, which has become central to judicial credibility in the digital environment. Courts hold sensitive information about individuals, business, governments, institutions, financial data, protected witness identities, confidential commercial records, all of which, being sensitive in nature, has to be protected at all levels. As courts digitize, risk expands like hacking, ransomware attacks, unauthorized access, improper sharing of documents, and data leaks. Judicial education must therefore go beyond how to use the platform. Digitalization also creates complex issues of procedural fairness and natural justice, especially in the virtual and hybrid hearings. The judicial education must help judicial officers navigate practical dilemmas like what to do when one party has poor connectivity, how to ensure equal opportunity to present their arguments, how to handle interpretational services and accessibility of accommodations online. A related challenge is that of the digital courts can unintentionally weaken open justice if not designed carefully. Traditional open courts allow public attendance, media scrutiny, and transparency. Virtual hearings may restrict access, introduce barriers for journalists or observers to create uncertainty about how to manage public participation without compromising privacy or security. Digitalization increases the importance of digital evidence literacy. Modern litigation increasingly includes evidence from CCTV, mobile phones, location data, emails, social media, messaging apps, cloud storage, metadata, and hence the judicial education must train judges to access authenticity, reliability, and context and to understand how digital endeavor can be altered. Challenges like fabricated documents, doctored screenshots, manipulated audio, and deepfake video require awareness even if judges do not become technical experts. A growing issue is the use of artificial intelligence in the judicial and legal workflow. AI-based legal research tools, case analytics, transcription systems, and administrative decision supports are becoming more common. Judicial education must address AI in two ways. First, as a productivity tool that can assist a legal research and court management, and second, as a risk factor that can introduce bias, reduce transparency, and create unequal advantage between parties. Judges must be trained to treat AI outputs as supportive but not authoritative, and to understand that AI may reproduce bias in data. Another digital challenge involves the training design and the pedagogy. Judicial education cannot be purely theoretical in the digital domain alone. Judges learn best through scenario-based methods such as simulated virtual hearings, mock e-file exercises, demonstrations of document management, workflow and exercises in handling objections, related to the digital evidence. In addition to these, there are also challenges of the institutional resistance and culture. Many legal systems are built on tradition, hierarchy, and established routines. Court staffs may fear that the digital system will increase monitoring, expose errors, reduce the importance of clerical roles. Lawyers may resist because digital systems change filing habits and court appearances, or smaller practitioners lack the sufficient resources for the same. The practical roadmap for the Commonwealth-oriented judicial education would include developing a shared baseline on digital competence, such as understanding e-file processes and case management workflow, skills of managing remote hearings fairly, literacy in digital evidence and forensic methods, strong cybersecurity practices. In conclusion, the digital challenges in judicial education across the Commonwealth are not merely technical. They are structural and value-based, touching equality of access, procedural fairness, open justice, security, and trust. Commonwealth cooperation offers a powerful pathway through shared knowledge, training modules, ethical standards to ensure that digital transformation supports the core mission of the judiciary, delivering justice that is timely, fair, transparent, and accessible. Thank you.
Thank you, Justice Samkoshi. We have 5 themes. The first one is shared digital repositories and learning platforms, then ethical frameworks for technology use in courts, AI in judicial research and training, technology infrastructure disparities, and institutional cooperation among Commonwealth judicial academies. These are the topics. I invite a co-moderator to start with the questions to the panelists. The answers may kindly be within 3 minutes. Not 3.
All answers or one answer?
One answer in 3 minutes.
Thank you, Madam. Good morning, all. The question is on theme 2, that is shared digital repositories and learning platforms, which again is very much integral to the theme of cooperation between the Commonwealth nations. Through its nomenclature, the Commonwealth jurisdictions presupposes shared resources. Whether developing shared digital platforms for judicial education by bringing together repositories, virtual training tools, and pooled resources, encounter any feasibility issues in the given situation of asymmetry in the infrastructure front. If so, what could be the appropriate standards and governance frameworks to be shaped? It's my privilege to put this question to Honorable Mr. Justice D.K. Singh, whom I believe that who had served 3 honorable high courts of this country and will be having vast experiences, particularly on a contextual basis. Sir, please.
Why are you stopping at 3 only?
More than 3. I stand corrected.
I must thank Justice Mustaq and entire team for organizing this conference and inviting me. Justice Oba always has great doubts about my ability to be on time anywhere. So yesterday I missed my connecting flight from Delhi to Bagdogra, as my flight landed late from Lucknow. So her apprehension grew more severe, and when morning I just landed at Bagdogra, she started messaging me.
Only 3 minutes.
That you are going to.
Only 3 minutes for the answer, you please. You can't finish.
So another thanks, another thanks is due because she sent me the questions in advance, so I prepared some answers.
My God.
So far as the question of the digital gaps in Commonwealth countries who share the common law system or the precedence-based system, that gaps can be closed by collective action. It is not by one nation, or it has to be a collective nations by all nations which are the part of the Commonwealth legal system and judicial justice delivery system. The states can share best practices and offer technical assistance through Commonwealth bodies. Infrastructure projects should be supported by smaller jurisdictions such as broadband or power updates. Commonwealth judicial institutions like CJEI can help by providing funding or training grants. This means sending technical experts, funding equipments and internet access, and providing online courses, that is e-learning tools free to under-resourced jurisdictions. In short, through multilateral approach, shared knowledge and connectivity projects under the Commonwealth auspices, we can work to ensure no jurisdiction is left behind. Clear policy framework and common standards, for example, e-courts and digital ID, should be developed jointly to lower cost and ensure interoperability, which is very important aspect. As Chief Justice of India said, I quote, democratize access to digital technology, I unquote, so that the innovation benefits all, not only to the well-resourced states or the nations. The innovation benefits must reach to all, and through membership program, ensuring even the last developed courts gain reliable connectivity and skills. Thank you.
Thank you, sir.
The next question I would like to put to Justice Kausara Dapagat, that is regarding ethical frameworks for technology use in courts. As courts increasingly digitize and store data in the cloud, what safeguards are in place to address risks such as system failures and potential data loss, as well as concerns relating to privacy and security? And how can courts ensure the securing of data sovereignty ethically and responsibly?
The question has two components. First one regarding safeguards to be put in place to address risks such as system failures and data loss, as well as concerns related to privacy and security. And the second one related to ethical uses of technology. You know, as the court embrace digitization, cloud-based storage, the judiciary must ensure that technology strengthens rather than undermines public trust. Safeguards are therefore multi-layered. On the technical side, it is desirable to have at almost all the courts in the country increasingly rely on redundancy and disaster recovery protocols, such as secure backups, failover systems, and continuing planning to guard against system failures and data loss. And encryption, access controls, and audit trails are now standards to protect sensitive judicial data from breaches, while compliance with international standards like ISO and IEC 27001 would reinforce security. And equally important is privacy safeguards. There should be clear data governance frameworks that defines who can access information, under what conditions, and for how long. This includes respecting principles of data minimization and ensuring that personal information is not retained or shared beyond a legitimate judicial purposes. And coming to the ethical aspects, technology is not only a matter of hardware or software, it's a matter of ethics as well. So, digital transformation must be anchored in ethics. Code of conduct for online hearings, digital evidence, and algorithmic tools are vital to safeguard judicial independence and impartiality. In Kerala, recently Kerala High Court published its policy regarding use of artificial intelligence in district judiciary. It is meant for responsible and restricted use of artificial intelligence in judicial functions of the district judiciary. It prohibits AI in judicial decision making while allowing it for administrative tasks. It mandates that AI must never replace judicial reasoning, requiring vetting of all AI generated content and restrict usage to only approved tools and protect confidentiality. So ethical use also requires ongoing dialogues across jurisdictions so that Commonwealth Court can learn from one another and uphold shared standards of fairness and integrity. Thank you.
Thank you, Justice Kausar. I think the question has been answered properly. Is there any doubts from the audience? If anybody has any doubt, 1 minute can be given for the audience. If not, we'll proceed with the other questions. You may proceed with the next question.
Our next panelist is Professor Stephanie Lawley-Shiloh, Professor of European Law and Reform. She is very much present with us virtually. The theme to which the question belongs is institutional cooperation among Commonwealth judicial academies. Madam, I think we are audible to you. Madam, please unmute. Madam, are we audible to you? You are not audible to us.
Please
unmute, madam.
I am audible.
Now.
Okay, now you are audible.
Now can you hear me?
Yeah, sure. Thank you.
Good afternoon, distinguished guests.
Shall I put forward the question, madam?
I have a question.
Okay, please.
It's a pleasure to be with you and to be listening to you. It's very interesting and it's of very high quality and level and standard. So I hope I can add a couple of points, maybe from a European perspective and linking with the Commonwealth via a couple of examples, if you allow me.
Sure,
Professor Stephanie, one thing, because we have time constraints and the answer may kindly be within 3 minutes. 3 to 5 maximum.
So I just wanted to give one example and then draw lessons from it. If you take the specific example in Cyprus, that there's a mixture of jurisdictions between the Republic of Cyprus and the British bases, the southern base areas in Cyprus, on the island of Cyprus, which are decayed territories, then everything that you have referred to before actually applies in the sense that it's essential to have some sort of Commonwealth judicial platform to be able to work together, because the judiciary in the SBA is actually following very closely legal developments in the Republic of Cyprus as opposed to following jurisprudence in the UK. So just to give you the importance of having a shared tool. Now, in my view, some of the additional points I could make on a judicial platform that would be of use for education purposes, but also for a judiciary, would be to go back to the basic principles of the rule of law in terms of, for example, how it was set up by Lord Bingham or equivalent. There are so many possibilities to look into principles of the rule of law, particularly the ones that are relevant to open justice. And since I'm speaking about open justice, I would like to come back to ethical values that were mentioned before, and perhaps bring to your attention actually an international project that was actually just completed on the importance of ethics values across research and integrity of research that could be of use. That was actually also that included an Indian partner in the consortium. And I could circulate, if you were interested, a number of the codes of conduct and codes of practice that actually use specific ethics values and explain how it is important for principles such as open justice. So these values are mainly care, as well as respect, particularly of local communities, as well as in terms of vulnerable groups and fragilized settings, fairness, and also honesty. And talking about honesty, this is probably what would be the definition of open justice. So, if I have 1 more minute, Madam Chair,
Sure, Madam.
I could perhaps, Mr. Chair, I could perhaps give you a little bit of updates of what's happening in the EU in terms of AI developments that are relevant to this conference. And well, it seems that we probably were over-ambitious when it comes to the development and the regulation of AI and AI systems. You may have heard that the EU had proposed and implemented a very ambitious digital transition, in addition to quite ambitious green transition. And in the past couple of months, or a bit more, 6 months, actually some of it has been undone, which is something quite unusual for EU law to actually be undone. Why? The main reason is that the changing world has put a lot of pressure on AI development made in Europe, in partnership with AI developments made in other places in the world, including, of course, India. And European development is lagging behind. Therefore, we are now having a new trend in a new set of measures. We qualify them as omnibus, and those measures are made to enhance more competition as well as technological development in EU. Of course, it can be in partnership with the international partners. And as a result, some of the very strict obligations that were supposed to be imposed, particularly on high-risk AI technologies, have been somehow a little bit relaxed, and that also includes obligations on companies. So I thought I would bring this to your attention. It's interesting developments to watch and see how a supranational entity can actually impact the development of AI across the whole continent and further. Thank you.
Thank you, Professor. Next question is from the team, AI in Judicial Research and Training. As we all know, capacity building for judicial actors through judicial education for the ethical use of technology in courts is crucial for ensuring that emerging innovations, particularly AI, enhance rather than undermine the rule of law and fundamental rights. So the question is, what will be the critical areas that need to be comprehended in developing ethical frameworks for the responsible and accountable use of technology by the courts across Commonwealth? The question is addressed to Barrister Prashant Barua, Barrister at Law, UK, Executive Member CLEAR, and as we know, these are the areas where cross-jurisdictional borrowings become very, very conspicuous.
Good afternoon, sir. Thank you very much. Esteemed faculty of talented audience, I'm afraid because we can't address the answers, but we can probably through the inquiries, and I believe these inquiries are all existential in the middle of cross-section and then entering into new era. Let me start giving and sharing an example. In last 3 months, 13 of British lawyers are barred professionally, 2 months to 12 months, absolutely based on their use of AI, and that's to be particular using unethically during their submission of bundle and even skeletons. And AI was so brilliant to bring several cases cited, and those later revealed completely non-existent. And resources, attention, and finally, they were accused misleading the court. So in my inquiry, actually, why I said it is existential, in UK courts as well, in district courts, even some federal courts, AI was given the charge to count the appearance, and they miscalculated. In the recent example, just last week in the Florida, the gruesome murder of 2 PhD students, Attorney General of Florida now actually bringing charge against ChatGPT because that was facilitating that gruesome murder, how to do that. The reason I'm telling that, are we becoming a colony of algorithm or colonized by algorithm? There is another example that algorithm was not 100% correct assessing the ground reality and blocking people for 72 hours to suspending the account in platform citing breach in community standard. But algorithm failed to differentiate between archival photos and real life sharing of those photos. So again, there is an accidental example on that. But the reason why I initially told the legal pedagogy, of course, presents not only the inquiry, but also faces the challenges that was faced by acclaimed Urdu author Krishan Chandra in his famous, the little story that's called Bikram Taxiwala. And then it was revisited in Tamil Nadu case Ramu. And now we see why technology is so pivotal and instrumental to deliver justice. And while I'm saying that, now there is a further question now echoing in the tech world, whether Google is a friend or foe to democracy, whether ChatGPT is a foe or friend, and why they're saying that, and how we can address those issues. I believe there can be, in some jurisdiction, they're experimentally using data bank and also harmony of data, and how they can protect data privacy, also provide transparency, and instead of maneuvering those data, how they stop manipulating those data safety, So I believe it is so technical series of questions and inquiries we are embraced today. But one thing is crystal clear. To avoid Bikram Texuala's and Ramu's experience and to keep justice delivery, the next generation legal pedagogy is demanding curriculum and training in the beginning. I know that I was also informed by Professor Shibir Kumar, our CLEAR president, that the work is on the way to promulgate benchmark clear guidance on ethical use of AI. I believe it's in the beginning, in the legal pedagogy that will answer some questions, but they are changing every day. They are changing every day. So I believe, dear audience, outstanding faculty of audience assembled here, the Gangtok conference or regulation can be later recognized as monumental to doing that, as the first paperless judiciary announced yesterday. So thank you very much. I believe you all have these inquiries in your mind, but in different jurisdictions in Commonwealth, we are trying to address them differently, but I think in passage of time, there will be a universal response, I should say Commonwealth response to the existing inquiries. Thank you very much, sir, again.
I think with the one last question, we have to conclude the session. Question. That is, how can Commonwealth countries work together to shape strategies to bridge the common manifesting gaps in digital infrastructure, which have a differential impact in the respective jurisdiction, and to ensure that judges across jurisdictions are equipped to manage technology-enabled justice systems regardless of the infrastructure disparities. With permission of Chair, can I put this question to Co-Chair?
Yes.
Sir, 3 minutes.
You should also let
Yes,
Yeah,
yes,
that's-
definitely.
that's
Yes, after.
As of now, it doesn't seem to be so easy to answer the query
Yes.
for the reason
Correct.
that all the different jurisdictions are still not clearly defined as to what kind of a digital infrastructure they actually need. So unless we are very clear in our mind as to the nature of the technology that we need for the technology-enabled justice system, it would be difficult. Whether it be it for AI tools or data storage or anything else, we need to be clear in our mind. If the purpose is clearly identified, first then the right infrastructure can be chosen. For example, high performance GPU services for AI or the large storage system for the data analytics, along with the networking, bandwidth and power requirements. Once both the purpose and infrastructure are clear, it becomes easier to set out a uniform standard across the Commonwealth country. This in turn helps us to estimate the cost, assess whether each Commonwealth country would be in a financial capacity to support itself, or would the other countries would be required to support the other country.
One thing I will add, technology is changing so fast that by the time you adopt one, a new one would have come. So that's another danger which we are facing.
Next, I invite the discussant to share your thoughts and conclude the session.
Good afternoon, Honorable Chair, Co-Chair, esteemed dignitaries on and off the dais, participants and delegates present here. It is truly a privilege to be a part of a conversation that sits at the critical intersection of not just law and technology, but tradition and transformation. What made this discussion particularly compelling is that it is not at its core about technology alone. It is about how institutions that are built on stability, continuity, and careful reasoning are now become asked to operate in an environment that is fast-moving, uneven, and constantly evolving. The panel has been remarkably rich in both perspective and experience, and from the thematic sessions, what has pursued is that the challenge is no longer simply about access to technology, but equitable access to justice through technology. And in doing so, I would just quickly add a few points that perhaps merit continued reflection. And these would be that first, the human dimension of digital transformation that judicial education would play a role in. So judicial education must now engage not only with tools, but how judges and our legal system in itself thinks, adapts, and decides in a continuously increasing digital environment. Second is the need of interoperability, wherein cooperation should move beyond exchange of ideas even in the Commonwealth, and it should align systems, platforms, and training methodologies at the same time. And lastly, one of the most important aspects that I feel is measuring impact. And in terms of measuring impact, as we see digital systems reform and expand, there is a need for empirical and stronger empirical assessments of ensuring that these systems enhance rather than complicate judicial efficiency and access. And that is one of the most important aspects, and I feel measuring impact should remain the core of deciding how far digital and digitalization and digitalization could go. So this has been exceptionally rich and forward-looking discussion, and what emerges clearly is that digital transformation in judicial education is not a technical project, but an institutional one. And perhaps the real task before Commonwealth is this, to ensure that embracing technology, we do not lose sight of the principles that gave judicial systems and legal systems the legitimacy that we have. Thank you for giving me this opportunity. I would like to thank Honorable Justice Mohammad Mustaq and the President of CLEA, Professor Dr. S. Shivakumar, for giving me this opportunity. And thank you, everyone.
As we conclude this session on digital challenges in judicial education, cooperation across the Commonwealth, I express my heartfelt gratitude to the Honorable Chair, Co-Chair, panelists, moderators, and participants for their thoughtful deliberation and valuable contribution. Before we depart, I would like to address the august gathering that a special dinner has been arranged for all our respected dignitaries at your respective hotels today. Thank you all for your gracious presence and participation. Wishing you all a pleasant afternoon. Jai Hind and Jai Sikkim.